Yeah. Well, I'm writing a research paper, but I'm also like trying to develop some tools to go with it and maybe use outside of the paper itself. Like I want to build up sort of a flow chart, so something that demonstrates the relationship between territorial personam and subject matter jurisdiction, and maybe even other things, eventually. But I want to start here with the basics.
Okay, so the relationship, you mean the historic relationships? Because, I mean, obviously there's no factual relationship. These are all abstract ideas.
The relationship between the claims themselves, the claims only, not anything factual.
Territorial, personam, and subject matter. Okay.
Yep. I made a post about this in the forum, and I was asking for some clarification on certain parts of it. I'm trying to make sure that I understand the arguments, that I actually know what they're asserting when they say they have this or that jurisdiction. I think I'm clear on the territorial argument, and that's, if you're physically here, then these laws apply, and that's it. That's the whole territorial argument.
Well, no, and the 2U part is the problem I'm having, because you instantly dragged in personam jurisdiction to the territorial definition. Our laws apply to everything that occurs in this area that we have jurisdiction over. There's always that we have jurisdiction over as a qualifier, which is always circular, but that's the nature of the beast, is that there is the presumption of itself. So they're defining what they're excluding. So territorial jurisdiction is probably better thought of as what it isn't. It is a claim to not have jurisdiction over anything outside of the territory, except that they don't generally abide by that either. If you're physically in Phoenix, then our laws applied to you is not what territorial jurisdiction is about, the way I understand it, or have ever understood it. Because it's not a you thing. They can have territorial and in rem jurisdiction, for instance, and not care about you, care only about your car. But there's the whole concept of at arm's length. If you are not at arm's length, or if a thing, or if a subject or something is not at arm's length to this territory, then territorial jurisdiction is satisfied, that part of it. But if you don't have jurisdiction, you also don't have any part of jurisdiction. It's a coincidence of all the needed elements of it to be right. That's a horrible sentence, I understand. It's talking about there is nothing wrongful about dictating on the subject of territory if you're not outside of the territory. But that only answers that subcomponent of jurisdiction as a whole. Then you move on to the next thing. Is there anything wrong with imposing upon the person involved? Okay, if not, then we've satisfied personam jurisdiction. Then we have, is it wrong for us to speak about the subject matter and impose in regard to the subject matter? And if it is not, then we have subject matter jurisdiction. All right, and if we've satisfied all those categories, then we've basically shown that there is nothing wrong with us imposing upon person, subject, place, the coincidence of events. And our orders, as long as they only involve those things, aren't wrongful. There's a taste in my mouth from even saying such sentences because there's so much lie in them. But
when we ask the question, has the prosecutor presented facts or evidence that the laws are applicable to give this court jurisdiction, we're speaking to all three? Because we've always talked about, well, I'll take the prosecutor's definition of it.
Well, that's because he has to actually contemplate all of it, or he's leaving out one of his essential elements. If he fails to accuse you of being subject to them, then he's failed to accuse you of being subject to them. If he says they're 50% subject to me, that doesn't really get him anywhere. If he goes with a definition of jurisdiction that withdraws his case, then that's on him. That's why we can defer to his definition, because if he alters his definition and goes so limited that he's no longer stated a case, all the better. For instance, if he says, okay, I mean personam jurisdiction only. Perfect. Thank you very much. So you agree that you have no reason to believe that you have territorial or subject matter or other jurisdictions. The issue of personam jurisdiction is a triviality the court shouldn't concern itself with, because it makes no difference if he has one part of jurisdiction,
Now that you've explained all that, now I have questions, because now I'm trying to figure out how is somebody going to actually formulate this argument then? How is somebody going to say, I have, what is the argument for territorial jurisdiction exactly? Like I'm, from anyone's perspective, from a prosecutor's perspective, from, someone talking about it on YouTube or whatever, right? How are they going to say that they have territorial jurisdiction?
In the opinion of the bar, it is a matter of competition with the other divisions of the bar, and that's it, right?
Sure.
So that brings in the diocese kind of argument, where it's like there isn't a place that I know of in the U.S. where there are two states that claim territorial jurisdiction. It is a mutually exclusive map, right? So that is the only issue that they see in territorial jurisdiction. So it's a matter of on whose ground it is. Now, that satisfies an argument between the courts, but not really an argument with the accused, unless the accused is related to one of the other jurisdictions. Like, let's say a governor, you try to sue a governor of another state, and you're like, well, he's like, well, you don't have territorial jurisdiction. I was sitting in my office. Obviously, he's raising territorial jurisdiction issues. But as an accused, where you're just like driving down the street, and that intersection isn't an intersection that, between the bar members, they have an agreement on whose territory that is. You're trying to get yourself into an argument that really doesn't concern us. You're trying to argue with the Catholic Church about what diocese you're in when you're not a Catholic. On this post, I see subject matter jurisdiction. A traffic violation was alleged. Therefore, this traffic court may hear the case.
Right.
An allegation doesn't create a case. An allegation doesn't make a case. You either have a case or you don't have a case. It really depends on the actual factual situation. He's alleging to have a case, of course. You cannot have a case against an actually innocent person. It can be up as a question as to whether they're guilty or innocent, but if they're actually innocent, you never had a case. Which, you never have jurisdiction against an innocent person who isn't voluntarily giving you some level of jurisdiction. But again, you can't be given subject matter jurisdiction over an innocent person no matter what you feel like doing. So it becomes a little bit of a catch-22 in the sense that it can't be right unless it's already right anyways.
Right.
Wrongful act cannot be made rightful by any mechanism involved in this thing, even if the target begs for it. The prosecution of an innocent person, there is no jurisdiction over innocent people. That's the problem. So you have to presume them guilty or take liberties with the idea, at least. Let's put it that way.
I guess maybe it would help if I clarified something. What I'm actually trying to address is not reality. What I'm trying to address is the fantasy of people in the legal system.
I get you. The problem is you're trying to make sense of a legal construct. I appreciate the topic at hand. Really, I do. This is something I've thought, read, and dealt with a bit. But of course, understanding the voodoo is different than accepting the voodoo. And in trying to discuss the topic of an innocent person who is accused of a crime falsely, who does not wish to be arraigned, this is a topic that lawyers really, really weird about. They don't have the tools to address the topic because there isn't a legal construct for it. And ultimately, that's what we're trying to discuss right now, right? We're trying, because the jurisdiction over a guilty person is a little different than the jurisdiction over an innocent person as a topic.
In a way, I'm really enjoying this. I'm really enjoying this perspective. But at the same time, it's actually not necessarily what I'm trying to discuss. What you're describing would be like pushing against the legal system as it is now.
Again, jurisdiction is the right to impose. I mean, in a rough, from the hip kind of way. It is a rightful. It is to say that it is not wrongful to impose upon someone, and that's what jurisdiction fundamentally means.
Okay.
So there is a way to exclude the word rightful and wrongful from this topic. If you wish to say that procedurally versus substantively, if you're only trying to look at procedural jurisdiction questions, not substantive ones, it's very difficult to unzip that. But if you're trying to say, presuming that the substantive jurisdiction issue is already settled as being there, as having jurisdiction, which is how I'm kind of interpreting what you're trying to tell me, is where presuming there is no substantive jurisdiction question, we're now discussing the procedural jurisdiction questions of territorial, personam, and subject matter jurisdiction. Is that what you're trying? Is that a good summary?
Yes, that is a good summary. So, like, if they're pushing against us, and the substantive issue is pushing back against them, but the procedural issue is going with their flow and like pulling them down instead. You know what I mean? Kind of like Mark's entire thing here. Like everything that he's doing is just taking what they're saying and running with it and pulling them down with their own, words, with their own arguments, their own claims.
You can't say that Mark's thing has anything to do with this because we've given up skepticism as the first step. When I said that in order to address the topic you're trying to address, which is the procedural mechanism about jurisdiction, we have abandoned the substantive question, which is it rightful to claim jurisdiction to begin with? We've already bypassed that question. So Mark's whole question, my whole question, the anti-arraignment position, the skepticism, you're already making me step past it in order to address these procedural questions.
Right, as a matter of practicality, and that's, I guess what I mean is like the way, all of this information that he's using to help people to actually defend themselves in court has to skip past that substantive issue, because then you can't address the substantive issue in the court at all.
I'm sorry, I couldn't disagree more. My life for the last couple of years have revolved around rejecting that very notion. You have managed to summarize the exact opposite of my position over the last several years, which I think is rather in line with with Marx and with skepticism and so forth. I'll leave you to judge that, but if we maybe can clarify a little bit, maybe we can kind of figure out where we're parting. Okay, so is it fair, I guess, to summarize Marx's position as a question of, do you have evidence of the truth of your claim of jurisdiction?
I think that's fair.
So it's not a counter-positive position. It is a challenge position. It is a Socratic position. So yeah. I'm not saying the opposite is true. I'm just saying, do you have evidence what you're saying is true, Mr. Prosecutor? We're not asking an issue of, have you satisfied the procedural requirements to move forward in a jurisdictional kind of sense. The jurisdictional procedures, the procedures set up to show, the procedures set up on the topic of jurisdiction. We're talking about the real meat and potatoes. Do you have evidence of the truth of it?
Okay.
Truth, falsity.
I see where I got mixed up, because I was thinking that, providing evidence to prove the truth of the claim was a procedural matter.
Evidence of something. So let's say you have evidence that something's true. That is a substantive thing. Now, there can be procedures that the opposing lawyer might use to try to get you to be unable to admit that evidence, even if it proves your thing. Even if it proves the truth of your side, they will try to get a procedural issue so that you can't discuss the truth. And it happens in court cases a lot. Well, that's been suppressed, so piss on you. You're just you look guilty even though we know you're not, because
right.
The evidence shows your innocence has been suppressed by procedural issues.